Hello. Welcome to Making Law Simple. My name is David Helm. I am a licensed practicing attorney in the state of Michigan, and I am currently sending someone who's been in the courtroom a link, and it went out. If you want to join me and talk about what your observations are from the courtroom, please feel free and jump on in. I will save your emails for a moment just in case we want to discuss them if you're able to hop on. But welcome, everybody. We had day 4 today. I did not do a review of day 3 because it was essentially sort of the same thing. There's really nothing special about it. But today we got to see parts of Ethan's journal that I thought would be appropriate to see, regardless of the defendant. Now, the comments were specifically regarding James, so most likely that's why they were admitted when they were not admitted under Jennifer Crumley's case. But they were admitted. However, there was also another bit of information. Hey, Jamie, welcome. That came in as well that I knew nothing about and wasn't expecting. All right, let's see if... Is it Mevka? Is that how we say your name?
Sure. Can you hear me?
Yes. How are you?
Oh, I'm doing all right.
I don't know why I thought you were a woman, but cool.
Hey, it works. Whatever.
So you spent, you were there Friday in the courtroom as well as yesterday and today. Am I correct?
Correct.
So on Friday, you said you felt like, you said you felt like you were driving through a maze, but
yeah. It's a horribly designed city of Pontiac.
Yeah. It's well, that's not even this. It's like on the outskirts of the city, but the complex, like there's everything there. There's the jail, there's the county like commissioner's offices, there's the court, there's the juvenile detention facility there. There's also the morgue and the medical examiner. There's like the county road commission. Everything is in this one complex. So yeah, it's not the most intuitive complex to find your way around. But you said that you thought the jury wasn't really paying attention when the defense was speaking, huh?
Yeah, correct. And I also do not think that they care as the court progresses. It seems like they care less and less, unless like guns are coming out or there's like videos being played. They're like kind of dozing off, just like looking. I don't know. They don't seem very interested.
Okay, that's interesting. A little disappointing. Were you there today when they were talking about Ethan's journal?
I was.
And was anyone taking notes? I know they can take notes and things like that.
Honestly, there's like juror number 5 takes notes or draws pretty often, but no one was really doing anything today.
I feel like that's disappointing. Hey, Kurt, welcome. Oh, you're muted. I don't know if it's my end or yours. So you had said that everyone wants to know who this woman was that the judge was talking about maybe kicking out. Well, it sounds like there was a woman there who was probably wearing an Oxford Strong shirt.
Yeah, so that was a father of, I assume, a victim wearing like a Oxford 42 or 38 or some number shirt. Mark Hurst pulled him out of the courtroom. There was like a 10-minute delay. The jury wasn't in the courtroom yet. And then when he came back in, he immediately grabbed like a coat he had brought and was forced to put that on. And another parent started yelling about him having to cover up his charitable organization.
Kurt, can you hear?
Hello?
Yeah,
How are we doing
now?
now?
We got you.
All right, great.
Now we got you. What about when they were playing the video of the shooting? Jung wants to know if anyone was crying or what the jury's response was.
Yeah, surprisingly, I only saw juror number 5 really crying, and like maybe juror number 4 was like a little bit. But surprisingly, when the vice principal was giving her testimony, there were way more jurors crying for that than there were for the actual shooting video.
Maybe they've been desensitized already.
Possibly, but neither video. I don't know. The videos are really weird to watch. They're way less violent than I would think they would be. It's just like a body drops. I don't know. It's hard to explain.
Okay.
There's not really gore or anything. It's really bizarre to watch.
Maybe almost like video game like.
In a video game, it seems more graphic. Honestly,
Okay.
it's like for one shooting, a kid just drops and then that's it. It's not like he explodes with blood everywhere. It's just a body falls.
Okay. Interesting. Kurt, you had said in the chat that you had noticed something.
I did notice something. I don't know if it wasn't mentioned during the first trial or if I only noticed it the second time around, but they were talking about what apparently Mr. Crumbly said during this meeting with the principal and the counselor, because they referred to the counseling session, which I'm pretty sure that's what they meant. And apparently Mr. Crumbly said, according to the testimony of the other witnesses, that you can write about it in your journal. And that was a detail that I had missed in the previous testimony. And I was like, oh, okay, because now I sort of understand a legal theory by which we can admit the journal. Because the trier of fact is able to conclude any fact and also any reasonable facts therefrom. So if he's aware of the journal's existence, which he must be because he commented on it, then it would be arguably reasonable for the finder of fact to conclude that he had read it, right, because he was aware of it. And if he had read it, now he has knowledge of it. And if he has knowledge of it, now it goes to his mens rea. So suddenly it becomes a reasonable extrapolation that a jury could potentially read to speak to his mental state. And it's like, oh, okay, now I sort of understand an idea of why we can offer it against him. And then I'm still a little bit stuck with why we can offer it against her, because I don't think she said anything similar. I guess the theory would be in legal theory, because she didn't say anything, she didn't act surprised, like, what journal, what are you talking about? That somehow indicates awareness by her. The lack of her saying anything is an indication of awareness, which I suppose. So now there is some sort of legal theory by which I can maybe get the journal in. So I was like, maybe I have something. What do you think?
That's interesting. It was brought up during Jennifer's trial, but very ancillarily.
I'll take your word for it. I just had missed it. I picked it up today.
I might be misremembering it because I watched a lot of the preliminary examination and I know it was brought up then because the entire journal just about was admitted during the preliminary examination.
Yeah.
So maybe I'm just remembering to a different hearing. But that's interesting. Yeah, he did talk about that.
If it wasn't brought up during her trial, then the reasonable extrapolation, if that's the idea that we're trying to work from, becomes less reasonable about her, because if she didn't hear it, then how do you prove her knowledge of the diary's existence? Unless she said something else that I'm missing somehow. So if the idea is because he said it and because she didn't react, she therefore has knowledge, therefore she read it, without testimony that the statement was said, you can't get to the chain of extrapolation. So I'm still confused a little bit on her.
Yeah. I guess I understand why it was, I guess I'm more focused on the fact that there's parts of the journal that were admitted under James, in James's trial here today, that weren't admitted under Jennifer's trial. And I don't see the legal theory as to why. So that's where all my focus is why parts of it that were admitted today weren't admitted under Jennifer's trial. And the fact that James seemingly knew about a journal and Jennifer said nothing about it. I don't know if that's enough.
I'm not sure any of it's enough. It's thin, but at least I can find a arguably cogent path to the end.
Right.
I'm
Now,
not sure
one
I
thing-
agree with any of this.
No,
It's just like
I
I
know.
it's like I could find a solution that kind of worked.
Yeah,
I felt
no,
proud of
I get that.
myself.
I don't agree with allowing any of it in if
Yeah.
Ethan's not there. Now, the one thing that was new that was testified to that I didn't catch if it was testified to in Jennifer's trial was that apparently Ethan had some videos that were on Twitter or YouTube or something of a Molotov cocktail. And I had never heard that before. When that testimony was going on, was the jury reacting in any way?
Okay, so I didn't note anything about them reacting during the Molotov cocktails, but they did respond to the guy claiming that the journal, like making the distinction between a journal and a notebook, they all seem to note something down.
Okay. Yeah, I do remember that when there was discussion of that. What about when the journal entry part was admitted that where Ethan said that his father had hid the gun, wouldn't buy a gun for him, didn't tell him where the gun was, things like that. I mean, was the jury taking notes at that point?
Today, no, possibly in previous notes I took, but today they rarely took notes at all.
Me, that's I don't know. I'm not thinking that's I don't know. We're reading tea leaves here. I was just very curious as to what the jury's sort of approach was. But you said like there's two jurors, or there's one juror in particular that's taking a ton of notes. That's probably going to be our jury foreman.
Well, there are two that are taking a lot of notes, but one seems to be getting very emotional. Like she has cried every emotional moment she can.
Okay. So Jennifer says, I have to disagree, assuming the father read the journal simply because dad knew he had one. I knew my teen had a journal, but I did not read it.
Yeah, well, I think that's a good idea, but if it's I was trying to find the exact language in the jury instruction because I was trying to find exactly what it said so I could quote it verbatim, but I wasn't able to find it while we've been talking.
You're talking
what
about the
jury's
jury
allowed to-
instruction.
when it comes to basically the evidence and reasonable extrapolations. I was trying to find the exact language.
Oh, I could probably find that here real quick.
Yeah.
Yeah, no, the other thing I was going to say is, wait, where are my jury instructions? Oh, they're not on this computer. I've been just pouring over the jury instructions for a trial like I coming up. I was literally just grabbing them. But let me pull them down real quick. In the meantime, the other thing I wanted to say is that apparently Ethan had multiple sets of journals, and I believe 2 additional sets of journals were found in his bedroom. And so if we're going to go down that route, we're going to have to sort of look at, well, what journal, because he spoke in the singular, was James actually talking about? Let's see, criminal jury instructions. Let me pull them up here real quick. All right, so we have evidence.
Presumably it's in Rule 2 somewhere. I just can't quite find it.
I hate the way they do this. Oh, elements of a charge, presumption of innocence. Let's see. When it is time for you to decide this case, you are only allowed to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of the witness, evidence admitted into exhibits, and anything else that you could consider evidence. That wouldn't be it. Let's see here. Let's see.
Isn't this fun when you have to do this on the fly?
I know, right? Well, this is how real
chapter
court
4
works.
somewhere.
Yeah, that's where I'm going now. Circumstantial evidence. It wouldn't be circumstantial. Let's see. Evidence of other offenses, evidence of other acts. Let's see here. Intent. No. Defendant statements as evidence. Let's see. I don't know.
This is good TV right here.
Yeah, I know. Circumstantial evidence by itself and a combination of circumstantial evidence and direct evidence. Let's see. Would it be under? Yeah, I know what you're talking about. It's something about, you can extrapolate through your common sense, blah, blah, blah.
Yeah.
I forget. Yeah. I know where it
All
is.
reasonable
Well, I know
inferences
for-
there too. It's like,
Yeah. Well, I'm not going to find it on the fly right now, but there is something like that. Yes. And I agree that there could be a legitimate argument for that. Again, at the end of the day, I don't want the entire journal in. What I saw during the preliminary examination, most of it is very, very bad. What I did want is the 3 statements that would, in my mind, exonerate James, in that his dad would not buy him a gun, did not tell him where the gun was, and had hid the gun from him. So those are the 3 statements that I really wanted admitted. I wanted it under Jennifer too, because I feel like you could argue that, listen, this is a partnership. This is a husband and a wife, a mother and a father. And you could say, listen, they're working as a team. The knowledge of one should be imputed on the other, kind of thing. But that's apparently wasn't allowed. I don't know. What is your thoughts on that, Kurt, with the imputing knowledge between a husband and a wife?
no, I'm not comfortable with imputing knowledge between a husband and a wife, particularly because that knowledge would presumably exist on the back of privileged communications, which seems like a double whammy.
Okay.
If the way that my wife knows about it is because I told her, then you've used the very privilege against itself. So that doesn't work.
But it's in favor of the defense in this one. So you should allow it, damn it. If we're going to skew the law, it should be in favor of the defense in my book. But that's not the way this works. I did want to go over the testimony of this guy. I forget his name.
I found it at least in a copy of a jury instruction, which just says you're only to consider the evidence of the case. However, you're not limited statements to the witnesses. You may draw from the facts you find have been proved such reasonable inferences as seem justified in light of your experiences. Inferences or deductions or conclusion that reason and common sense lead you to draw from the facts established by the evidence of the case. So is it a reasonable inference to assume that if he's aware of the diary or the journal, that he's read the diary or the journal? Well, maybe. I mean, if you ask me if I'm aware of a book, then it might indicate I've read it. It's certainly some evidence that might suggest it. So maybe you can get there.
I don't like that, though, because then you're allowed the inference that he knew that this plan was in place, because that's what this whole journal is about, is his plans. So at the end of the day,
well, that's interesting, because if you had knowledge of the specific contents of the journal, then you could argue that actually provides a problem for the prosecutor, because if he does have specific knowledge of the journal, then why aren't we charging him with second-degree murder?
Or as the state said in Jennifer's case, first-degree murder.
Whatever.
Premeditated.
However, Michigan, in its great druthers, defines second-degree murder. There's no uniform rules. Is it first degree in Michigan? Who the hell knows? Whatever. It doesn't matter. Some really bad murder bad. That one.
The way they framed it, if we knew that if the way they said it in Jennifer's trial, if we had evidence that she knew ahead of time, we would have charged her with first degree.
So wait, yeah. So now I'm confused, because now you're eating your own tail. It's like if they did know, we would have charged them with murder. So we didn't charge them with murder. Therefore, we don't believe they knew. Well, if they didn't know, now we're back to where we started. How are we bringing this in? And around we go. I'm very confused. Is this a mutually inconsistent pleading thing? Does Michigan allow that? Are we arguing both that they did know and didn't know at the same time?
Yeah, we can have mutually inconsistent.
Outstanding. Things. They both did know and didn't know at the same time. Great. Fantastic. Love it.
When Karen lost her shit. Yeah. So this guy is Timothy Willis, by the way. So he's Oakland County Sheriff Detective. The other great thing about this testimony on cross-examination, which I wanted Jennifer's attorney to do and she didn't, but this one did, was narrow down the dates of the journal entries. because she was able to say, listen, the gun was purchased on November 26th. So at the very least, this journal entry was made after that, which doesn't give very much of a window in order for the parents to have read the journal or have known or have suspected anything. So I thought that was good. Is it Mavica again? I don't know how you pronounce it.
It's fine. Whatever you want.
I mean, anything from the jury at this point when any of this stuff is being brought up?
Okay, so on like when he started making the like it's a journal, not a notebook argument, I didn't see any response from the jury. Like no one noted anything down. Sorry. When on cross, when what did he say? Oh, like the journal's in his backpack, and then he said, "I know it's his journal." There was no response from the jury then, and then after on like redirect, everyone wrote it down shit about the journal. So like that redirect seemed really effective, even though it was like, I don't know, 3 questions.
The redirect focused on dates specifically of things that happened in the past. So he was the state was trying to get past the argument that the journal was written after November 26th by referencing things that happened like on November 11th and prior dates. That was, in my opinion, the bulk of the cross. That's when they were taking notes.
Right. They don't seem to like, honestly, they kind of look annoyed during the defense's cross, which is kind of scary.
Yeah, I don't like that at all. Did you note yeah, I guess. Did you stream this at all, Kurt, on your channel? Kurt? Oh, okay. I don't know if he's reading cross or not.
Yeah, I was reading. I'm sorry, I lost the plot.
No worries. I was just wondering, did you stream this at all? Did you like watch the whole thing?
I did stream it a lot. I did stream it today, which is why I caught on to the thing that I wasn't paying attention to earlier the first time. So yeah.
So we have James' admission, or somewhat of an ancillary admission that he knows about a journal.
Yeah.
We have the admission of the additional 3 passages from the journal.
Yeah.
We have testimony regarding a Molotov cocktail video. I didn't hear anything else new from today that wasn't already in existence in Jennifer's trial. Did you?
No, it's mostly the same. And apparently the state's also done with their testimony. So tomorrow we're going to hear from the defense, presumably.
And I said before, I would really want a psychologist to testify.
I want someone who can talk about the predictability element. That's what I want. We've talked about this before. The state apparently has an expert we can use. Let's use him. That sounds good. Let's get him on the stand and talk about how even the experts can't predict this.
Exactly.
I mean, why not? Sounds good to me.
I want that African guy.
From
the Miller hearing. The African guy who had like a crazy accent, which his accent would like change rapidly throughout his testimony.
You mean the guy who was dropping the egg in the courtroom? That guy?
Oh yeah, that guy. I want him.
That would be a disaster of a shit show. But no, there was a specific expert that the state wanted to call, and the judge said, by your very own admission, Mrs. Expert, Dr. Lady, whatever, or there was another guy too, both of you, you can't predict this. So I'm not going to allow it in. It would be...
wait, wasn't it? I thought it was the defense motion in limine. Did the defense do this to themselves?
So
because the judge presumably wouldn't have ruled that way unless the defense brought it up.
Yeah, so it's called.
Did the defense make an oopsies?
No, the defense called the Daubert hearing, which is when you get notice that the other party is presenting an expert. You can challenge that expert ahead of time during an evidentiary hearing, and that's what took place. So it was defense motion to basically not allow this expert witness to testify, and they had the evidentiary hearing.
Yeah, I don't even think that's correct, because the lack of predictability doesn't mean I can't testify to it if I've done that in a rigorous way. You know, if you get me on the stands and be like, hey, Flipping a coin, is it going to be heads or tails? It's unpredictable, man. We've run 80,000 different experiments, and we just can't predict if it's going to be heads or tail. I mean, that's a scientific fact that we don't know how to predict random. Amazing. Wow, deep, right? So it works for me.
Yeah, actually, you could present it. You could present the same witness and
that's what I do. That's what I'm saying. I'd forego cross, bring him on my own onto my own case in chief as direct. Let's talk about how things aren't predictable. Let's talk about that a lot. You have scientific evidence things aren't predictable, and people don't actually know the future. Wow, thanks. That'd be great. Yeah, let's get that guy.
Yeah, no.
Is he available?
I don't know who else are they going to call. The other interesting thing is the whole reason this case got bifurcated is because supposedly the state wanted to call 2 witnesses from Florida, put them on the witness list. That's what caused the defendants to bifurcate the case. I haven't heard any witnesses from Florida testify, not in Jennifer's case. And if the state's done, then they didn't call them on this case.
I was under the impression it was because they wanted to point the finger at each other.
So, according to the motion that was filed, it was because these 2 witnesses that were identified in the state's witness list that are in Florida or whatever, live in Florida, I don't know, some sort of Florida connection, were placed on the witness list, and that is what caused maybe that wasn't the real reason, but that's what's contained in the motion to bifurcate. And then
the state was trying to force a separated trial. Why would they do that?
Well, I don't know that the state was trying to. The state just included 2 additional witnesses, and these 2 additional witnesses somehow caused a conflict between the parties.
Well, obviously the state doesn't need them. So if that was the issue, then presumably the state could be like, yeah, never mind. You can strike them from the list.
Did I miss it? Did we hear from the student that the state fought so hard to keep on their witness list?
I did not see any students yet. I believe that the student they were fighting for is KO or R something, but neither of them have appeared yet.
And they're not going to appear because the state's done. So
that was supposed to be a witness that was going to be called in their case in chief. The other potential witness that the defense tried to keep out was the prior owner of the gun that was used. But I think that was more for rebuttal purposes, according to the state, when they were arguing their hearing about that. So maybe that person is still yet to come. Which, I mean, who would the defense be calling or have on their witness list that would require the prior owner to be a rebuttal witness? That's interesting as well. Just trying to extrapolate here who the defense, what their actual strategy is, other than he didn't know and he did everything he could for his son, which seems to be the obvious argument.
Yeah, I think all you can do is lean on he couldn't know. I'd also be arguing like hell that the jury instructions have to specifically say the jury has to find that they would have been able to predict the shooting would have occurred that day, since the Court of Appeals said it twice in their decision. That's a reasonable thing the jury could conclude. I'm like, I want that as part of the jury instructions, because that's apparently what the Court of Appeals said. So put that in the instructions.
Yeah, well, Jennifer's trial,
it did not include those instructions, nor was there a hissy fit over the lack of inclusion in the instructions. So did their attorneys miss a trick?
I think they might have. There's a lot of things that have been included and excluded from this trial and cross-examination that I feel is on point that Jennifer's attorney really dropped the ball on. But again, it's not going to rise to the level of ineffective assistance to counsel.
Oh no chance in this world. No chance in this world. If she simply missed something, Yeah.
Mapka, are you going back tomorrow, or are you going to stay through the rest of the trial?
Yeah, I think I will go back tomorrow, but I don't know how much more I'm going to go after that. I got laid off on Thursday through the 18th, so I got nothing else to do. Spree entertainment, I guess.
Cool.
Yeah, why not? Well, the courthouse is usually populated with unemployed people and attorneys.
Right. The craziest thing about this whole trial so far is when that Earth, Wind, and Fire song is playing, no one in the whole courtroom laughed, and I was just trying to hold my.
I was doing
my
singing
laughter.
over here. I didn't know the murder occurred the 21st night of September. I thought it was a different time, but okay.
It was so tough. I don't want to laugh. I'm sitting right behind a bunch of victims' parents, right? So
Oh yeah, no.
it's very tough.
This reminds me. I ran up because I thought that was so hilarious. I ran a community post on my channel a while back. I said, "What should be in the mixtape for the police to play to get you into the mood to confess?" That they're going to play. So I can read you some of chat's suggestions if I can find it real fast. Oh, here it is.
Yeah, I'm curious to see what the suggestions are.
Folsom Prison Blues, Johnny Cash.
Nice.
One Way or Another, Blondie. Breaking the Law, Judas Priest. Another One Bites the Dust. Going Down by Joe Bossameus. Confessions Part 2 by Usher. Let It Go. Suspicious Minds by Elvis. Bad Boys, What You Gonna Do When They Come For You? That's a classic. Every Breath You Take, I'll Be Watching You. That's a good one. I like that.
There's a song by The Offspring. I'm trying to Wella Wella. I'm going to add that to the
Wella.
Wella Wella by The Offspring. It says, "Goodbye, my friend. You messed up again. You're going to prison. You're off to the pen."
Yeah. I like it. No,
Yeah.
It sounds good.
Yeah. I used to listen to that when I was a prosecutor, right before like trials and stuff, just like amp up because it's really heavy. Back when I was a baby lawyer and didn't know what I was doing and was nervous in the courtroom.
Mama Tried by Marie Hager. That's a good one.
That's awesome. Bohemian
Man in the
Rhapsody.
Mirror, Michael Jackson. I'm asking him to
man.
change his ways. There's some good. There's some good ones on here.
Way Down We Walk. I don't know this song. I wish I could play songs on this without getting demonetized because I just have a ball. That's the problem. I was playing a lot of songs in my earlier streams before I was monetized, and now all of them got demonetized. I'm like, I guess I can't play that anymore. If you're under 18, you won't be doing any time. Yes, that is Wella Wella. That is
There you go.
That's a good song. Yeah.
There you go. Let's try that one. Yeah. For the
Oh no, wait,
juveniles.
that's is that come out and play? I can't remember. Wella Wella. Now I just closed it down. Was that in Wella Wella or was that come out and play? Offspring's got a lot of good songs related to this. You just rock Offspring in the back of the cop car. They'll talk.
There you
go. But yeah, that was so weird when they kept playing that song. The other thing is I was thinking, like, it's kind of bad on the cops to have the music playing. When you put two suspects in the car, you want to maybe not have music playing so you can hear what they're saying to each other. But anyways, let's see. If James is acquitted, would that help Jennifer's appeal? No.
No.
Has no bearing whatsoever.
Short of a miracle, no.
Somebody asked this earlier in chat too, that if it made a difference that the cases were bifurcated. No, you could acquit one and find the other guilty in the same trial, and it wouldn't make a difference.
Yeah. Juries do weird things sometimes.
Yeah.
Or even less weird things. And we've seen stuff like that where you have multiple defendants and they don't necessarily come down the same. One example was the killing of the black gentleman jogging through the Atlanta neighborhood. With the men in the truck, and there were 3 defendants, and they weren't all convicted of the same things.
Yeah, that last guy, the one that wasn't the father and the son team, but it was like the other neighbor. I think the first 2 counts, it was not guilty, or at least the first one was. And I was like, oh, this guy might get off. And nope, he was convicted, I think, on the last count or whatever. But yeah. No, it wasn't the dumpster defenders. It was the guys that were... the dumpster defenders is another example. Though.
Was that Ahmaud Arbery? Was that guy's name?
No.
Ahmaud
Dumpster defenders
is the Atlanta guy.
Yeah.
The dumpster defenders was the father and son. Where the
yeah. With those guys got They didn't go. They didn't even go to the grand jury. I think. Did they get a no bill from the grand jury, or did they not even go? Either way.
I don't remember what the grand jury was. I just remember the first prosecutor apparently knew the defendants and didn't recuse herself quick enough.
Yeah.
So now she's in a bunch of hot water. I don't know. I don't know whatever ended up happening with that case, but
Yeah, take your swing. Inviting the confrontation.
Am I missing?
Yeah, that
I'm
was a good one.
conflating so many freaking cases.
Yeah, there's too many cases in my head. There's too many cases in my head.
Take your swing. I think I've got actually some of his stuff. Wait, hang on.
Yeah, you can't invite the confrontation. Yeah.
Okay.
So.
Yeah, don't invite the confrontation. Oh, actually, did you hear that Ohio Supreme Court the other day said that a warning shot is perfectly fine in self-defense now?
I did not hear that.
Yeah, I just saw I saw a little blurb about it. I haven't dove into it yet, but according to the Ohio Supreme Court, like the general rule is like if you have a chance to take a warning shot, it could be considered.
Yeah, it's because it's like, how imminent is it if you have the time? So.
Yeah, but apparently, according to the Ohio Supreme Court, I haven't dove into it yet. They made a ruling that you could take a warning shot and it still be self-defense, I guess, somehow connected. So that'll be an interesting case to look into. Actually, I think Bronco's looking into it, if I'm not mistaken. I wouldn't be surprised. I would be surprised if he's not. But so we can do warning shots in Ohio, and parents are going to prison in Michigan. How does Texas fall in all this?
Well, Texas is still a death penalty state, so you want to bear that in mind.
That's true. That's like the most concerning thing. There's like a quote like, "I'm going to Florida. Don't do anything because they got the death penalty when you're in Disney."
Texas uses it.
Yeah, that's true. But I was going to watch a little bit of this guy's testimony. I don't know if you wanted to stick around the whole time.
No, bounce for now. I just wanted to share my potential revelation with you and see what you thought of said potential revelation. I've got actually work to do.
I'm going to pull the jury instruction. I'm going to think on that. Maybe I have some more thoughts, but I'm just wondering, like, would it be a net benefit or detriment to James if we went that route too? If he knew about the journal and he had read it, I don't know. I like the idea that he's never, he knew about a journal, but not that journal. That's what I prefer.
Yeah, well, as they pointed out, we couldn't find any other journals, just like we apparently couldn't find any other gun locks. So there's apparently no ambiguity about what the journal is because there's only one, I guess. So.
All right. Well, take care. Are you streaming later today?
No, I actually have actual work to do, so I'll do actual work.
That was me during the day. So, all right. Well, thank you very much, and take care, everyone. Go sub to Uncivil. I'll put a link in the chat and then in the description. But we're going to check out this guy's testimony.
All right, I'll bounce. Bye-bye.
All right, take care. And then Mavka, I didn't know if you had anything else you wanted to, or if you want to stick around.
Yeah, I just had a couple questions for you. First of all, why is this guy even allowed to testify? Like, he's been sitting on the jury or on the prosecutor's counsel the entire time. That seems like garbage to me, especially because he gets like defense amnesia as soon as he starts getting questioned.
I know. It's amazing how that happens, right? But no, this guy is apparently the lead detective. So he's the one that's heading up the entire investigation. And so in that position, he is allowed to sit at the prosecutor's table and assist the prosecutor in trying the case. The idea being that the defendant can sit there and assist the defense counsel in trying the case. And so the state should have the same thing as well. And it is the same when it comes to a civil matter as well. Like if you guys ever watched my MLS Goes to Court stream, you'll see that both of my clients are there, even though they're representing a corporation. Now, technically, I was allowed to have one there. I argued to allow to have both of them there, and the judge ended up granting it. But in theory, I'm allowed one person to assist me with the trial of the case. And so was the defense. So they can sit through it all and participate in this to assist counsel. That's the idea behind it.
Well, they also have that reptilian ATF guy who's been there the entire time and remains there.
Yeah, and so he's a little different because he was qualified. Maybe I'm wrong. Was he qualified as an expert? But the idea is that if someone is an expert witness, they're still able to sit and listen to the testimony because it helps them form their opinion. So I thought he was qualified as an expert. I may be wrong on that. And then otherwise, I would have no idea why he would be allowed to sit there.
And my final question is, when this guy was being cross-examined, could the defense introduce evidence then as well?
Yeah, the defense can always introduce evidence when they're examining somebody. So you can introduce evidence at cross-examination, or you can wait until you call somebody on your direct. Usually it's strategy. Like, you don't want to admit evidence that you don't have to. So you want to kind of wait and see what all the evidence is first. And then, or maybe it would be more favorable to admit the evidence with a favorable witness. So, it's all comes down to strategy and how you want the evidence to be seen. What are you thinking that they could have admitted under this guy?
I'm not entirely certain why I wrote that down. To be completely honest with you, I don't know. And the final comments I have is, chat, whenever you guys hear all this coughing and banging and all these other garbage noises, that's all media people, okay? They are the loud people. Every other person in the courtroom is silent and respectful. It's just the media who are loud and obnoxious. Every cough, every bang, everything is just the media.
Of course it is, because why wouldn't it be? There was a member of the media when I was there for jury voir dire for Jennifer Crumley's trial on day 1 that was taking a picture with his phone of Jennifer Crumley. Now, the jury wasn't in the room, and or prospective jurors anyways weren't in the room. But the rule is no photography at all was going to be allowed during jury voir dire. Yeah, he's up there taking a picture. Court officer and the sheriff had to come over and be like, "You didn't take a picture, did you?" And he's like, "Oh, no, I was going to, but then I didn't." The media is a mess. That's all I have to say.
Yeah, I heard that during day 1, I believe, like someone was like apprehended for taking a photo of the jury.
That was during Jennifer Crumley's case. There was somebody, I don't know what day it was, but there was someone who took a picture, and contempt proceedings were brought in her case against this individual. But I wasn't able to follow up with it yet and figure out exactly what happened. But yeah, so I don't know if it was a member of the media or who it was. Also, during the Jennifer's case, there were issues with members of the media talking to jurors and asking them if they were a juror on this case. Now, they ended up being a juror for a different case, but still, that was bad. So I don't know what's going on with the media. I thought they had higher standards. And if a certain chatter was in the chat right now, she'd be going all over me. But it appears that the media doesn't really have those high standards anymore.
Yeah, the only person that seems to act professional in the entire place is Charlie Langton, who I didn't have respect for before, but now I have a little bit for.
Okay, fair enough. Charlie, you said Charlie Langton?
Correct. Yeah, from Fox 2, I believe.
Oh, yeah. Okay. Yeah, I saw him actually in the background sitting there. He's been there the whole time, hasn't he?
Yeah, he just sits quietly with a notepad and takes notes. He doesn't have a phone sitting on the bench, vibrating the entire bench every 30 seconds. He seems like a upstanding guy.
That's funny. I know, was it you that was telling me that one of the media members was like coughing and the judge was scolding that person, saying, "Hey, maybe if you're sick, you don't show up"?
Yeah, at the end of day 2, I Googled and I found out they were from the Detroit Free Press, I believe. Or the Detroit News, one of the two.
I know who you're talking about.
The judge basically said, like, "Hey, if you're sick, you shouldn't be here, or you're distracting the court." And that person hasn't reappeared.
Oh, okay. Interesting. Well, that's good. At least she kind of took the hint from the judge. I know who that, or at least I think a shorter woman.
Well, the first initial starts with a C, if that helps.
No, that doesn't.
I don't know. The first name's Kara. I don't know the last name.
Okay. Let's see.
All right, that's all I got. Unless you have questions for me.
So Cheryl says that he reported today that half the jury was crying at the video. Is that accurate?
Half the jury was crying at the video. I don't think so. I think 2 members were really crying. Maybe the other ones look sad. A lot of them have. Personally, I have what's called resting bitch face. A lot of the people in the jury also seem to have that, and they show very little emotion. Like 2 people notably were very teary.
Okay.
But I wouldn't say that half the jury was crying. Half the jury was definitely crying or more during the vice principal's testimony.
Okay. That was at 5. We'll go check it out. We'll go watch it. And there was another question here. Oh, yeah. Can anyone recommend the Parkland trial? I know you guys have been chatting. I don't know who covered the Parkland trial. Oh, who's the guest? Farrell, this is Mevka. I don't know how. I guess that's how we say it. I'm just going with Mevka. He's actually a local and has been hanging out in the court the last couple of days. So just giving us some feedback on what he observed from the jury. I'm concerned, but I hope to be like concerned, but then pleasantly surprised at the end of the day. Did they do a mutual sequestration order in this case? I didn't hear one placed on the record, but I would have to imagine they did. I don't see why they wouldn't. And the witnesses are being brought in from outside the courtroom, right? When they call them?
Correct.
Okay. So, yeah, then there's definitely a sequestration order. So, well, thanks for popping on and thanks for your emails. Let me know if you go back there and if you want to come back on
no
again.
problem. I'll keep you updated.
All right.
All right. Have fun. Good luck.
Thanks. Take care.
Peace.
They mentioned that yesterday. Okay. Maybe they did. Yeah. I did think he was a girl. But now I'm glad to be corrected. All right. Let's listen to this guy a little bit because this was interesting. All right. I have it at 1.25 speed. Closed captioning is not available, so deal with it. But this is not cross. This is direct examination of what's his name? Timothy Willis, Willas, Oakland County Sheriff Detective. This is the part that I really wanted to listen to again. So you guys are watching it with me again, because if I'm going to watch it, I might as well stream it.
Now, at some point, was there a concern about explosives in this one?
Yeah. So as I was stating earlier, I was getting sent and others were getting sent and observed Twitter, now X posts, Instagram posts, YouTube videos, and we had came across a YouTube video of the defendant's son making a secondary explosive device, potentially more commonly known as a Molotov cocktail, and detonating it. We, at the time, and we'll talk, I guess, about the journal, we found some
I thought that was inappropriate.
Like,
we're going to talk about the journal. Okay. Well, you weren't asked a question about the journal, sir.
That there may be secondary devices in place within the school that prolonged my ability to go and investigate the scene of the crime, because we had to continually sweep to make sure that the area was completely safe.
Okay, and in fact, did you have to call a specialized unit to handle that?
We did. Yes, Captain Hill, he activated the.
Yeah, right. So the video of a explosive device, Molotov cocktail, was never brought up in Jennifer Crumbley's case. It was never brought up in the preliminary examination. And I've gone over a ton of documents, and this is the first I've ever heard of it, which I find amazing. But there was no objection, so.
Michigan State bomb squad with their bomb dogs, and they came in with their robot.
Now, were you able to determine what room or area of the school specifically the shooter left right before he began shooting?
Yes, it was the bathroom adjacent to room 258.
Okay, I'm going to show you what's been admitted to people 16. What are we looking at here?
This is the backpack and contents that the shooter was seen, observed wearing, walking into the bathroom prior to the shooting beginning.
Okay. Now, was this photograph taken after the location was made safe by the bomb squad?
That's correct.
Okay. And they didn't find any explosive devices?
They did not.
Okay. Now, what do you see in this picture? What was seized as evidence?
The most obvious thing is you see the book open, that is the shooter's journal.
Okay. Did you have the...
So that brings up another question then. The Miller hearing, there was a lot of stuff that was brought in that wasn't brought in Jennifer's trial and still hasn't been brought in James' trial. Like the bird video. And if this was brought up in the Miller hearing, I don't remember it. But why is it allowed to be admitted now? And is there any evidence that he saw it? I don't know. It's weird. Again, no objection, so I don't know.
Opportunity to review that journal?
I did. I have.
All right. Were you able to identify it as being written by the shooter?
Yes, sir.
How are you able to make that identification?
There's, first of all, his name's in it. That was the most glaring way to identify that it was his. His writing is unique and it matched some homework and other writings that we saw. There's references to several incidents that occurred in the school within the month of November, things of that nature.
Okay, so you, from the content of the journal itself, you're able to put a time frame on when the journal was likely written?
Yes, sir.
And tell me about that.
The first date written would have been November 9th. But it did reference incidents that happened before that.
Okay, in the month of November?
In the month of November,
Okay,
yes.
as well as incidents that happened after that in the month of November?
Yes, sir.
Okay. How many pages of writing are contained in that journal?
22.
Okay, so is it filled with...
So just because the first time frame reference to something in the past was November 9th, that's when it was written? I don't think that's right. But still, let's assume November 9th. That gives the parents less than a month to have discovered all of this. Plus, there's only one date, and it's November 29th. So there's really no telling on when exactly he wrote this.
Writing from front to back, or is it different parts, or how is it?
No, it actually appears to be written from back to front, and it stops about a quarter way through.
Okay. Now, of the 22 pages, is there, I guess, a title page or something to signify the end of the journal, end of the writing?
Yes. I mean,
okay.
To answer your question simply, yes.
So out of the pages with writing in that journal, how many contain reference to the school shooting?
All 22.
For the record, I'm going to show you some of these slides, or some of these passages rather from the journal, and I'm going to refer to them by page number. And just so you're clear, sir, they're indicated page 1 from where the writing starts to page 22, which would be the back binding of that journal. Is that accurate?
Understood, yes.
Okay. Now, is the journal in written format or drawings contained as well?
Both.
Okay. Were there any passages in this journal that you noted indicative of the shooter's request for mental health help?
Yes.
This is People's 359. Can you read what's written in this passage, please?
Yes. I have zero help, and help is bolded, for my mental problems, and it's causing me to shoot up the fucking school.
This is page 5. For the record, that was page 6 on the journal. Same exhibit, page 5. Could you read that, please?
Yes. I want help, but my parents don't listen to me, so I can't get any help.
That's page 5. This is page 19. What does it say?
My parents won't listen to me about help or therapists.
All right. Now, were there any journal entries about the shooter's desire to obtain a 9mm handgun?
Yes, sir.
Same exhibit, page 3. Can you tell us what this is, please?
They have no dates for any of this, Josie. They reference events that happened November 9th, November 11th. The only date that I'm aware of is November 29th or something like that, which is the day before. That's actually written in the journal. And then he does talk about purchasing the gun, which would have been after November 26th.
Yes. The shooter writes, so we should be bound to get my SD 9VE soon.
Okay. Now, that specific term, SD9VE, did you see that anywhere else in this case?
Yes, I did.
This is People's 85 and 86. What do we see here?
This is a picture of a Smith & Wesson model number SD9VE. that was for sale that was extracted from the defendant's phone.
Okay, and Mr. Rogowski testified this was from Monday, November the 8th, sent from the defendant's son to the defendant in a message that was deleted. You were here for the testimony?
Yes, I was.
Now back to the journal. This is page 22. Can you please read us what this says?
Yes. The shooter writes, I want to shoot up the fucking school so badly. Soon, I am going to buy a 9mm pistol.
Same exhibit, page 17. Go ahead.
So that was presumably before the gun was purchased, which I believe was on November 26th.
All I need is my 9mm pistol, which I am currently begging my dad for.
And page 22.
I will
This
have
is the binding, right?
The binding,
Okay,
correct.
go ahead.
I will have to find where my dad hid my 9mm before I can shoot the school.
See, that's the one that I wanted in because it shows that the firearm was hidden, that he didn't have access to it. For whatever reason, he wasn't allowed unfettered access, as the state has been alleging. So this one I thought should come in and should apply to Jennifer as well. Sort of the, partnership one act sort of thing. But it didn't come in.
And page 15.
Unfortunately, my dad does not want me to get the 9mm gun, and we are having financial problems, RN, for right now. And I don't have a job, so now I'm pissed because I want to do the shooting with a 9mm pistol as they are effective for killing. But RN, right now, all I got is a puny 22 LR Keltec that I don't know where my dad hid it.
Okay, and we heard evidence in this case that James Crumley obtained a 22 caliber Keltec pistol in June of 2021. Is that right?
That is right. Yep.
Were there journal entries regarding the shooter's plan?
Yes.
Okay, here's page 3, same exhibit. Can you read this, please?
I'm about to shoot up the school and spend the rest of my life in prison.
Sir, did you find any journal entries
Sorry,
regarding
Sandra,
the
ask
shooter's
the question again.
access to the 9mm?
Yes, I did.
Same exhibit. This is also page 3. Go ahead.
Excuse me. First off, I got my gun. It's a SP 2022 6-hour 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I am fully committed for now. So yeah, I'm going to prison for life, and many people have about 1 day left to live.
See, and this is where I think if you use Kurt's theory that dad knew about this specific journal and had like access to it or something, that you could impute the fact that he read it, even though they have no evidence of it. I think it would make it worse. And I'm curious as to why they didn't admit, maybe the defense will, because if I remember correctly from the preliminary examination, there were 2 other journals in Ethan's room that apparently the state doesn't want to talk about. So maybe the defense will.
So we saw one of the journal entries that had the word help all bold that was across
I think
a
it
couple
was in
lines.
construction of some sort.
Were there any other writings or passages in that bolded format?
Yes, there were, sir.
Were there pictures in the journal as well?
Yes, there were.
Okay, like what?
There's a picture of what appears to be an arm fully extended out with a gun pointed to the back of what appears to be a female's head.
Okay, and was that a little picture or a large picture?
Well, according to the state and Jennifer Crumley's trial, if they had direct knowledge that they read the journal, then they would have been charged with murder. I don't know how they get there, because to me, it would just prove potential manslaughter, not murder. But that's what the state said.
It took up about that much of the page.
Okay, so to reference,
Oh, I'm sorry, about 3-4 inches of the page.
now was this journal a full-size book like this legal notepad, or was it small?
It was small.
Yeah, but I don't think that's correct.
400%.
Not according to the state's witnesses in the preliminary examination. Maybe the defense is going to address that. I don't know.
This would be 381. This is a demonstrative exhibit. Any questions with it?
Objections? No, Your Honor, just for cautionary purposes.
Put a pair of gloves. Just take that. you just hold it up for the jury so they can see, please? And
Maybe that's what the defense counsel is building to with the questions regarding notebooks versus journals, because I believe that was brought up during cross, and so maybe they are going to be addressing it. I hope they present a defense.
thanks, sir. That's what's depicted here in People 16 that we're referring to?
That's correct. If this was laid open.
Yeah, first one.
Sure.
Would you mind putting it back in?
Yeah, they just admitted the bad ones where he talks about wanting to shoot up the school and planning it for months or whatever, planning it for a while. Those are the only ones that.
Sir, we've heard evidence and we've heard the 911 call that James Crumbly made on Tuesday, November 30th at 1:34 p.m. You're aware of that call?
Yes, sir.
And you were in court when it was played?
Yes, sir.
Okay. Now, we've also heard testimony that the Meyer and Ray Road next to the high school was the emergency location for Oxford High School parents in case of emergency at the high school.
The reallocation point, yes.
And did the police likewise notify the community of that as well?
Yes, they did.
Okay. Do you recall when that occurred?
I believe the first 911 call of that the sheriff's office dispatch advised that the Meyer will be the relocation point was at approximately 1 o'clock. Well, 1 o'clock in that day. So just 10 minutes or so after the shooting.
Okay, so the shooting began at 12:51 p.m. This was 1 p.m. the same day?
Yes, sir.
Are you aware how many 911 calls were placed to dispatch in that time period?
Yeah. Sure.
I was muted. I'm jumping forward now to cross-examination, just so you guys know what's going on.
This is exhibit 2. How did she die, sir?
She had a autopsy.
And those are the 4 students. Nothing further.
James looks upset.
Good afternoon.
Good afternoon.
Go back to November 30th of 2021, when you were made aware of the shooting at Oxford High School.
Okay.
You testified today that you were at the prosecutor's office,
I was.
and you were advised, you said by the prosecutor and your chief assistant, that was the chief prosecutor, Ms. McDonald,
Correct.
and her chief assistant came to the office where you were discussing another case.
We were in a conference room in their office and they came, yes.
Sympathy and
The prosecutor
emotion.
asked you about the swear-tos that were conducted, both for the charges made against him and the charges alleged against his son as well, the charge made against his son. Do you recall those questions?
I do.
And the prosecutor confirmed with you that the process for the swear-to is open to the public.
That's correct.
You said that both the public and the media were present at the swear-tos for both Mr. Crumbly's son and also Mr. Crumbly.
That's right.
For Mr. Crumbly's son, you made note that Mr. Crumbly was not present in person for the swear-to in the arraignment.
Yes, I stated he was he was there on Zoom.
And if you recall, his son was also on Zoom for the arraignment. Is that correct?
His son was in custody.
But they were. He was not there.
It wasn't after the video.
That's
It
correct.
was after the testimony regarding how the kids died.
After the Oxford High School shooting on November 30th of 2021, do you recall receiving tips and receiving information and were made aware of concerns for the safety of James and Jennifer Crumbly after their son's name had been made public, if you recall?
I don't recall that.
Do you recall that their residence had been identified publicly?
I don't recall it, but if I can explain, I think I do know that there was media was there, but I don't recall it being released anywhere, if that makes sense.
And I'm not suggesting that law enforcement released that location. Obviously, you talked about the social media posts,
Yes.
that there was a lot of information coming into you and your department. There was a lot of information being made public that wasn't necessarily true. There was a lot going on at the time on November 30th of 2021, separate from the tragedy at the school.
That's fair.
You said that on December 2nd of 2021, that you and the prosecutor's office were having discussions about possibly charging James and Jennifer Crumbly.
That's correct.
I think one of the major issues for Jennifer's case is the journals. Now they've come in on James. So, yes, for both of them, mainly for the confrontation clause. But Jennifer even has more so because there's parts that weren't admitted. If you're going to admit part of it, and not all of it, I think she has a stronger case for evidentiary issues with regard to the journal.
You know that at some point on December 2nd of 2021, not necessarily the nature of the, or I'm sorry, not the content of the discussions, but the nature of the discussions about potentially charging was made public.
I'm not familiar with that.
If you recall, there were media reports and information put out into the media that James and Jennifer may be facing charges.
That may be true. At that point, I was completely involved. Like, there was things that came out in the media that people tell me about today I have no idea about, because I wasn't.
Yes, and you had a lot going on. And obviously, when I ask you a question, I'm just asking you questions about what you know about.
I understand.
You knew on December 2nd, you testified.
I don't think an offer was made to James other than plead straight up, which wasn't going to be an option.
Today that you knew on December 2nd of 2021 that James and Jennifer Crumley were not staying at their residence.
Yes.
You knew that they left on November 30th of 2021.
Correct.
And that was before charges had been announced against them,
Yes.
and before there was any sort of information that may have been put into the media that charges may be forthcoming.
Yes.
That was in fact the day of the actual Oxford High School shooting that they stopped staying at their residence.
To my understanding, yes.
The prosecutor showed you Exhibit 362, which is a Holiday Inn Express receipt, correct?
Yes.
And if you recall, the room was registered to Jennifer Crumley,
I believe you.
if you recall.
I don't recall, but I believe you.
You know that at some point on December 1st, James and Jennifer left. Oh, and before I go past that, you also know that on November 30th that James and Jennifer Crumley obtained those track phones from the Walmart in Lapeer.
Yes.
And we looked at that receipt as well.
Yes.
And you testified that you learned during your investigation that there was a conversation either with Detective Sergeant Brian or Lieutenant Marsban about James and Jennifer obtaining those phones.
Yes.
And the purpose was because they had given their phones to law enforcement and they didn't have any way to communicate with people, if you recall the information they were given.
They were taken in a search warrant. Whether they gave them to, I guess, is subjective. But yeah, we obtained them, and it's my understanding the advice given to them, which again isn't uncommon, is that purchase some track phones so you could maintain communications.
Exhibit 3.
But just the way that information came out is so much better than what Shannon Smith was doing. Mere fact that their phones were seized by the police and they were advised to buy track phones took Shannon Smith forever and a day in arguments and made her seem, I don't know, it was just a mess to get that out. And she got it out. No problem. Very easy. Yes, he is facing the same 15 years.
65, you know that on December 1st of 2021 that James and Jennifer left that Holiday Inn in Lapeer and checked into an extended stay in Auburn Hills.
What day did you say?
December 1st of 2021.
Yes.
Now Lapeer, for those who aren't familiar, is north of Oxford.
It is.
It's north of Auburn Hills.
It is.
So they left the Lapeer area and came down to Auburn Hills, which is 15 minutes south of Oxford. I could be wrong about the time.
But you referenced Lapeer essentially borders Oxford.
Okay.
And
On the north
side, and then you got Rochester. 20 minutes. I don't know.
Okay, I won't lock you into a time, but they came and they came slightly south of, still in Oakland County, correct?
Yes.
Okay. You noted specifically that there was an Auburn Hills Police Department across the street from the extended stay.
Yes.
Now, you know that Jennifer and James Crumley checked out of the extended stay on December 3rd of 2021,
Yes.
which was that Friday.
Yes.
You don't know what time they left the hotel, correct?
If the checkout's on the, but do I know? No.
In my Discord, somebody, I can't remember who, posted like the wanted posters for them, which was dated December 2nd. But the warrant wasn't sworn until December 3rd, which is the day they checked out of the hotel. And in fact, the warrant wasn't sworn until after I believe they already had gone to the art studio.
You know what time checkout is,
Yes.
based on the receipt and the documents, correct?
Yes.
But you don't know what time they left, whether if it was at checkout or before. You have no idea.
That's right.
At some point on Exhibit 368 is the T-Mobile receipts from the T-Mobile in Owasso.
Okay.
Those are dated December 2nd of 2021. if
Okay.
you recall.
Yes, I do.
And there was some conversation about the distance that Owasso is from Auburn Hills, because on December 2nd of 2021, James and Jennifer Crumbly had been staying at the extended stay in Auburn Hills.
Yes, and I believe they went to Owasso to get their phones.
Right. They drove to Owasso to get their phones and then went back to the extended stay, from what you understand.
Yes.
So they didn't stay in Owasso, correct? Overnight, to your knowledge.
No.
I got it,
Now-
ladies. I got it.
You are aware that after the Oxford High School shooting, there were a variety of reactions and emotions to what occurred at Oxford High School.
Yes.
There was terror,
From whom?
anyone at the school.
More than likely.
There was anger.
Are you
I'm
just
speaking
talking
in general. In general.
I would guess after an incident like that, every emotion imaginable could be.
Right.
Okay.
You're aware that once the identity of
I'm saying that at least by the day before they were actually indicted, they were getting their ducks in a row to go pick them up. That they weren't, the normal process is you go swear in an arrest warrant and file a complaint, and then you go look for the person. They had everything lined up ahead of time. That's what I'm saying.
shooter at Oxford High School was made public, you were also made aware during your investigation that a lot of that anger, or some of that anger, was directed toward the parents of the shooter, James and Jennifer Crumbly.
I can't say specifically, no.
Exhibits 371 and 372 were the videos from 1111 Bellevue in Detroit.
That's a good question.
You noted that there was a difference of 22 minutes on the timestamp on the video from the actual time.
Yes,
So the video was 22 minutes ahead of what the actual clock time was, if you recall.
I think that's right.
The video, I believe it's 371, shows that James and Jennifer arrived at approximately 10:59 a.m. at 1111 Bellevue.
Okay.
And that was prior to the swear-to that you testified was conducted at noon.
That was prior to.
That I believe it was around noon, correct?
And again, I'm not asking you to lock in on the exact time, if it was 12:01 or 12:02 or whatever the time may be, but 10:59 is obviously before around noon.
It is.
And the two
Good
videos
question.
that you were
Explain
shown, that exhibit 372 is after 4 p.m., where it shows that James Crumbly walked out of the building and turned the car around and then went back in the building.
Yes. Was it 417 or something like that?
Correct. So the two clips that you saw, there were actually many, many clips from throughout that day, if you recall, that you reviewed as part of your investigation.
Yes.
In fact, as part of your investigation, you reviewed those clips and know that one or both of James and or Jennifer Crumbly were in and out of that building on more than one occasion on December 3rd of 2021.
I don't recall.
So Jennifer's case, the state's case in chief lasted 6.5, halfway through the 6th day. So yeah, and we are on day 4 and the state's resting. That's 2 days less.
Do you recall that there was video of James specifically leaving the building to smoke and going back in on more than one time?
I can't say. I don't.
And we heard, you were in here when Investigator Creer testified,
Yes.
and he talked about finding, I believe he said 14 cigarette butts next to the Kia
Yes.
in the
I don't know
1111
why
Bellevue
that's
parking lot.
important.
Yes.
So you don't specifically recall whether or not James and Jennifer did leave the building.
Yeah, so the horse testimony, the affair testimony, that really cut it down. Plus all the shenanigan arguing back and forth, and Shannon Smith taking 45 minutes to ask 10 questions.
You don't recall whether they didn't. It's fair to say you just don't recall.
That's right.
I didn't hear that either, Aaron.
You testified that at 4 o'clock, a judge ordered James and his wife to turn themselves in.
Yes.
You don't know whether James had knowledge of that order from the judge.
I mean, it's safe. I mean, there's some evidence in my mind that points to that he's aware.
Okay, so this is the other part that I wanted to compare. I'm not going to play the cross-examination from Jennifer's trial, but the fact that like the timeline, they were on the run sort of thing, this is so much smoother of a cross. We're getting to the part, and then I'm going to speed up and see if the state actually said that they ended their case.
You did not see anything in your review of the case and of the evidence that you've obtained in this case to suggest that James was not going to turn himself in. And I'm not asking about anything that you've seen that you may or may not be able to talk about, but I'm asking specifically, you haven't seen anything to suggest that they weren't going to turn
She'll have
themselves
to object to the form of the question. She can't try to pigeonhole witness if he has more information and then limit the answer in his basic knowledge.
Well, it was kind of a long question too, so but you're specifically asking him.
Your Honor, I'll rephrase my questions a little bit because it was multiple questions. You asked, and we heard the testimony, you asked retired Sergeant Hendrick to locate James and Jennifer Crumley on December 2nd of 2021.
That's correct.
That was on the date that there were discussions about potentially charging James and Jennifer Crumley.
That's correct.
On December 3rd of 2021, they had not been located at that time, earlier in the day,
What time?
before dark.
No, they weren't located.
They were
To my
located,
knowledge, they weren't located.
right. To your knowledge, they were located later in the day, and we heard the testimony about that information, correct?
Yes.
I don't know if he
You
will. I
testified
don't know
about
if he should.
a video, I believe you said it was posted on Twitter of the shooter, a Molotov cocktail or something.
It was, I believe it was a YouTube video.
Okay. You have no information that James was aware of that video.
No.
Okay.
Now, Exhibit 16 is a photograph of the backpack and contents in the back room that we looked at.
Okay.
The photo shows that the journal that was in the backpack was open, and I believe you testified that that was opened by law enforcement.
To be honest, I'm not, so if I can recap that, the Michigan State Police Bomb Squad went in there. They arranged the items to my understanding, and that's how, the first time I saw that, that's how it was.
Okay, so you don't have any specific knowledge about how that was opened or who opened it. You just know that when you saw the contents, that's how they were as they were in the photograph.
Right.
You identified the journal as that of the shooter because his name was in it.
Yes. Among other things.
Right. You said also the writing matched homework that you saw and things of that nature. The first date that you have written in the journal you testified was November 9th of 2021.
I believe that's right.
You indicated that there were references to incidents prior to November 9th of 2021, but you don't specifically know what the dates were that those incidents were written about. Is that fair?
I think I might,
Based on reading the journal.
based on everything I've read.
Okay. So based on everything you have about all the knowledge you have about the case that you learned after November 30th of 2021, you may have additional information.
Yes.
But looking at the
See, that was a good way to phrase it. Based on everything that you've learned after November 23rd, you may have, reason to think otherwise. Framing it as a nobody knew at the time. Okay, I'm going to jump forward here because apparently there is maybe resting. I don't know. We'll see. Let's check this out.
9th of 2021.
Yes, sir.
Thank you. I'm sorry. Thank you, Judge.
All right, can you be excused?
Yes, Judge.
All right, you can step down and be excused.
Thank you, Jeff.
I have no idea. We haven't seen the
Tell me
witness
where we're
list.
headed.
Judge, we have no further witnesses today. Before we officially rest, I'd like the opportunity to review our exhibit list. We had a lot of modifications throughout the case.
All right.
We want to confirm with defense counsel what was extracted and added on. And then tomorrow morning, we'll know for sure.
All right, do you want 9 o'clock?
That's fine, right? Yes.
9 o'clock.
Okay, so they didn't officially say that they're resting. They said we have no further witnesses today, and that tomorrow, overnight, we're going to confer and see if we have any additional witnesses or anything else, and then we'll let you know. It sounds like they're probably resting, but it's not official yet.
All right. I'm going to ask you to return at 9 o'clock tomorrow morning. Please know again that during the trial, you should not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and lawyers must be able to cross-examine
Does it
them.
happen on this
Because
feed or
reports
my
do not have
feed?
to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media, do not post, do not do research, do not discuss the case with anyone. We really appreciate your commitment to this very important job. And we ask you to hang with us just a few more days. We're nearing closings within the week, I would think. Remember to fill out your lunch form for tomorrow. See how.
Okay, so he said, okay. I missed it. And the lip pouty thing might have been like a let's hope so kind of approach. Maybe she's talking about a directed verdict or something.
Maybe tonight, and don't discuss the case with anyone. Any questions about the schedule? Any questions about that? We appreciate you. Thank you.
All rise for the jury.
The ATF guy needs to get out of there just so we could see James primarily, but for other reasons.
Please be seated and remain seated until the defendant is removed from the courtroom. 9 o'clock tomorrow. Right?
Yeah, trying to make it.
The cafeteria is good, though. I like the cafeteria. It's got a variety of food. Might be expensive, but it's not like typical cafeteria food. Okay, so that was it. The squeaking is pissing off your animals. All right, so I have the sun setting behind me. Oh, and that was today's trial. That was the important parts, or at least the parts I wanted to talk about from today's trial. I've been trying to angle this away. Here we go. All right. Yeah, I know. What is the deal with the ears? He has headphones on, which are connected to the courtroom audio because he is hard of hearing. So that's what's going on with that. Have they sent it to Jennifer yet? Sentenced? If that's what you're asking for, no, it's April 9th, I believe. I'm going to log off into the sunset. Who should I send you guys to go chit chat with? Jung, I tried to pull up the video that you were talking about, and I'm not sure exactly what you're referring to. What is the gag order for? So there's been a gag order in this case since it began, preventing either side from talking to each other. But James was issued an additional sort of gag order, and that he cannot communicate with anyone except for his attorney until after the verdict is reached. All right, who's streaming what? Let me see here. Okay. I am going to redirect you all. Let me get this set up. And it is confirmed. All right. Thank you, everyone, for sticking around. I am... Oh, I see. Yeah, I don't want to. Yeah, I know, Shannon Smith. Maybe we'll do another stream where we compare a little bit more Shannon Smith. I will be back here at 9 a.m. tomorrow for day 5, which might involve a directed verdict. We will see. And let's see. Yeah, that's it. All right, take care, all. Have a good one.
When I was young, my